so it's not just a matter of saying, you know, we have to be equitable. We have to call out the injustices where they are. The way that you do that, one of the things that's been done, again, out of New York, with the Vera Institute, is that they went around to prosecutors' offices across the country and said, show us your data. Show us whether or not you charge, for example, in drug cases. If blacks, whites, and Latinos use drugs at the same rate, why are African American men 4 times more likely to be arrested and charged for it? And if we aren't looking at that data, if we're not peeling that back, policies that are saying, oh, this doesn't seem right, we're not going to get anywhere. So dealing with the structural issues by having transparency, by looking at demographics, by opening the data, and then dealing with it. And we have to stop looking at our criminal justice system absent from other things. So we have to talk about mental health. We have to talk about public health. We have to talk about education. We have to talk about poverty, because it's not just an issue of race. It's not just all black people are getting treated different. You can pinpoint the neighborhoods where we have the highest concentrations of violence and the highest unemployment rates and the highest incidence of people coming back from the penal institutions. And if we are not investing in those communities on the front end, separate and apart from our criminal justice system, and dealing with those issues, we're going to continue to see a cycle of people, particularly poor African American men, coming in and out of our criminal justice system.
Thank you, Kim. You know, interestingly enough, Donna, in doing the research for today, I found that there are some 30 different diversion programs that actually do exist in Cook County, but few attorneys and defendants know anything about them, especially black and brown defendants. Do you see these programs as valuable, listening to what Kim just said in terms of looking at the different issues that come with the criminal justice system, such as mental health, education, underemployment, no employment, etc.? And what would you do if you agree with these programs to advance the programs and, more importantly, put it out there as a part of the culture of the new state's attorney's office?
So first of all, I think diversion programs are very important. I think it's the future of criminal justice. When I first listened to Ms. Alvarez describe that she started with 2 diversion courtrooms and has now 22, I guess I was under the mistaken impression that somewhere we actually had 22 courtrooms doing diversion cases. We don't. What we have are portions of a judge's call devoted to diversion courts. And you know, what the studies show is that's not the right way to run a diversion court. The more effective way is that you actually have dedicated courtrooms for veterans, for drug addiction, for mental health. And that's what I would, number one, seek to do. The other problem with our diversion courts under Ms. Alvarez is how do you get in them? So the policies as to what cases they will take are very different than, in my mind, what it should be. So let's take a veteran returning home. You cannot get into a veterans diversion court if you have a DUI, if you have a gun case, if you have any kind of violence case. Now, when you analyze it, of course, when our veterans come home, those are exactly the kinds of issues and problems that they have. So why aren't we putting them in a diversion court? And the reason why is because Ms. Alvarez is all about convictions. And when you're all about convictions, you don't take the tough cases because you don't want to do the work and you're afraid that you might not get a conviction. And so we have to turn the table on how we handle our diversion courts, whether it's mental health. I mean, they can all be in one courtroom, but again, you want your assistants and you want your judges to understand who the folks are appearing before you. The most amazing thing that I witnessed, having visited different jurisdictions with dedicated diversion courts and having been there on graduation day, right, is that your prosecutors, your public defenders, your probation department, your mental health care professionals from outside the court system, or the addiction programs like a Haymarket or the VA hospital, the judges, they all want the same thing, and it's not to convict somebody. It's actually to have somebody show that over the past 18 months or 24 months, they have proven worthy to get their conviction dropped. And at the end of the day, and there's not a dry eye in the house on graduation day, and at the end of the day, do you know the first person that these would-be defendants go up and thank? They thank the state's attorney for having the faith in them, for believing in them, and for working with the whole community in that courtroom to see to it that their felony charge got reduced to a misdemeanor or that the charge went away altogether. And as I said, not a dry eye in the house, but that is the future of what our criminal justice system will look like.
Kim? I think the problem, I agree, diversion courts are necessary. The problem is that we don't have diversion to scale. So the needs of all the people in our county who have mental health or drug addiction or the need does not meet the scale. And so if you have programs that only allow a couple hundred people out of, tens of thousands of arrests, and you're cherry picking who you want to be in those programs because the state's attorney wants her numbers to look good, you're leaving behind the people who need those programs the most. And that's what the issue is with the diversion programs that we have now, is it doesn't meet the needs that we have, and it's wholly controlled by the state's attorney who wants to control the outcomes. So if you want to make sure your program looks like it's successful, when you measure it, you try to pick only the cream of the crop to come into your program. And a lot of those times, those are people who are probably more well-funded than others. And so we need to be serious about diversion, but I think we need to look at it beyond just courtrooms, but a real holistic approach in how we talk about criminal justice. We have to stop talking about criminal justice in silos. And again, I'll go back to, and it's something that we did in juvenile court, where every defendant that came before us, or every minor respondent, we were trying to figure out who is this person, and how do we make sure that whatever our outcome is going to be for them ensures that they don't come back. So if it's drug issues, counseling issues, or the like, we're doing that on every case. To pigeonhole people into courtrooms to deal with their issues when we know that most people who have drug addictions have also a mental health component to it. They're dually diagnosed. And trying to figure out where we're going to slice and dice you to give you the treatment that you need is not a good use of our resources. And so we have to be more out the box in our thinking. We have to say, look, we got the third largest public health system in Cook County, and we have Affordable Care Act expansion under county care. Let's get people who have drug addictions into the proper venue. We have mental health issues in the jails where a third of our people are there for mental health issues, and we don't have the mental health clinics to deal with them. And the state's attorney's office is not downstate in Springfield telling Governor Rauner, how dare you cut mental health services because they're coming to our jails. Or how dare you cut foster care services because those kids are coming to our jails. We've been very passive in the state's attorney's office and she's been passive and patting herself on the back for ticky-tack programs instead of doing the real work and getting down to having a holistic criminal justice system and not a diversion courtroom.
Ladies, I'm going to ask our timekeepers to impose 30 seconds for the next couple of questions because I'd like to get to as many of the community questions as possible. The first question, what will you do to ensure that defendants are charged fairly, avoiding time in jail and ensuring their rights to a speedy trial? It is very well known that people often spend years in county jail waiting for some half-butt charge that ultimately gets dismissed. And the reason why is because they can't make that little piddly bail, which if you can't make the bail, you have to sit in jail. Oh, I sound like Johnny.
Well, it's a lot to answer in 30 seconds, but, okay, thanks, Star. Here's the thing. We, as state's attorneys, have to handle the cases that come into our courtroom, and continuing a case does not make your case any better. I always like to say a bad case doesn't get better with time. So the issue is, under the Speedy Trial Act, a by agreement date doesn't count against the days. that you have to bring your case to trial. And so what that means is, within a reasonable amount of time, maybe not the first date or second date, but within a reasonable amount of time, I want to see state's attorneys answer ready for trial. And if they answer ready for trial, then the defendant has to take a continuance if they want it. And, you know, at some point, you have to say to the judge, look, 3 or 4 continuances by the defendant are unacceptable. We are ready for trial. We have our witnesses here. We are ready to go. That's in felony cases. The misdemeanor situation is much worse because someone will sit in jail for, you know, 3-4 months. We pay for it at $150 a day, and their case, 80% of those cases get dismissed. So let's figure out what to do on the front end, and let's use that money for something better.
Okay. We have to move from a cash bond system here in Cook County. The fact of the matter is that the number of the people who are in our jails are there because they cannot afford their bonds. So right now, we have somebody in our jail who had $20 worth of drugs in their pocket, but they have a $1,000 bond. But Jason Van Dyke pumped 16 bullets into a child and paid $100,000 to get out.
Right, I don't know.
That is a problem. That is a fundamental problem. And so when we're talking about bond court and making sure that we're holding people who are a threat to the public and need to be separated, that's who should be in our jails. Being in our jails simply because you are poor and cannot afford to get out should be unacceptable and inhumane. So using alternatives to detention is an easy give. We did that here in Cook County. We went to the Supreme Court and said, we have 10,000 people in our jails on any given day. This is an embarrassment. They intervened, and what we saw was we had people there because they were poor. In 2 years, we dropped the jail population by 20% without risking public safety by saying if you are poor and cannot afford to get your bail, you will be on an alternative to detention. And we need to do more of that and have a program in place that has a real risk assessment that says bond is or you're held only if you are a threat to the public or you're a flight risk. Everybody else, you get an alternative to detention.
And let's be very clear, ladies. These people that are in jail waiting all these months and sometimes years on little penny ante cases, where are they going to abscond to? Okay? It's not like they're going to leave the neighborhood that they have lived in where their mama, grandmama, and them are. So why are we not just living in the truth? Okay, we'll start. All right, another question. Mrs. Betty Jones is murdered by a police officer. The same police officer murders a young man. The officer now sues the estate of the young man for having shot both of them. I'd like to add, as an attorney, let me say allegedly murdered. Let me say killed. That works all the time. He sues for emotional distress. This community member wants to know why.
Well, you'll have to ask his lawyer and him why. I don't believe, I'm not sure, but I don't believe we've ever had a case brought by a police officer relating to his emotional distress.
Because he had to kill somebody.
Right, exactly. I haven't read the complaint in the case. My sense is it may get thrown out on a motion to dismiss, but you'd have to ask the officer and his lawyer as to their judgment as to filing that case in the first place.
Insight, Kim?
No. I mean, it's just pure tomfoolery. I mean, I think this is what we've come to in Cook County. This is what we've been reduced to in Cook County. It's just pure foolishness because we haven't had real leadership in our criminal justice system to hold people accountable. That someone would have the audacity to believe that they could do something like this because we have not had real leadership. And so I have no explanation for foolishness other than we need to have real leadership in our criminal justice system so that people are not inclined to do dumb things because they think they can.
Okay, next question.